I like to tell people, thanks. I think I like to tell folks is that, we are going to be talking about sexual harassment. We're going to be talking about sexual violence, and these things can be upsetting and they can be triggering for folks. So, if you need to take a break and step away, please feel free to do so. And I've got some resources at the end of the presentation for some great community resources if you need to talk to anybody after this presentation, if this is bringing up any feelings for you and you need some support. So we'll put those up at the end of the slide. And I'm going to pass it over to Scott now to start. Thanks, Scott.
Sure. Thank you. Thanks, everyone, for joining us today. Just as we get started, I wanted to offer a land acknowledgement. And we are on the traditional lands of the Mississauga Anishinaabe, the Haudenosaunee, and the Chinootan peoples. And in the Haldimand Treaty of 1784, 950,000 acres were designated as the Haldimand Tract and promised as protected for members of the Six Nations. And that has not been kept. So today, only about 48,000 acres remain. And I also want to talk a bit about Two-Spirit folks. Settler presence here has disrupted thousands of years of culture and belonging, and that includes the loss of understanding of Two-Spirit people. So pre-colonization, Indigenous people recognized Two-Spirit as a sacred way of being. A Two-Spirit person is said to carry in them the medicines and teachings of many genders and sexualities. And Two-Spirit people had always been regarded as important, respected, and fully accepted members of their communities. The histories and teachings of Two-Spirit peoples have always influenced and added to Indigenous ways of knowing. And of course, land acknowledgements like this cannot accomplish any kind of justice on their own. So I'm pleased that Spectrum has several different programs for Indigenous folks and allies. So if you're interested, we have a monthly all nations sharing circle, where every month there's a different Indigenous elder or knowledge keeper who comes and talks about a different topic, and allies are welcome to join that to learn more. And we also have a monthly language circle where you can learn some basic Ojibwe. So you can find that information on Spectrum's online calendar if you're interested. And the reason we're here today is that it's, pardon me, International Pronouns Day, which takes place on the third Wednesday every October. And if I can talk and text at the same time, I will share a link. There you go, to the Pronouns Day website. And this slide gives you their sort of mission. So referring to people by the pronouns they determine for themselves is basic to human dignity. Being referred to by the wrong pronouns particularly affects transgender and gender nonconforming people. And together we can transform society to celebrate people's multiple intersecting identities. And I think the next slide will just give a very brief intro into some pronoun stuff. But I'd like to show a video.
Sorry. Oh, is it there now?
There we go. So this is a short video featuring some local 2S LGBTQ folks talking about the importance of pronouns.
I'm trying to get it to play. Just bear with me for a second.
Hi, my name is Lynn McGinnis. My pronouns currently are they and them, but I want new ones.
My pronouns are she, they.
My pronouns are she, her.
And my pronouns are he and him.
My pronouns are they, she.
My pronouns are she, her.
My pronouns are him and his.
My pronouns are she and her.
My pronouns are she, her.
My pronouns are she and her.
My pronouns are she, her, they.
My pronouns are she, her.
I use they, them pronouns. For me, she, her pronouns affect my mental health, and he, him pronouns kind of feel not quite right and sometimes a little bit unsafe. And so they, them pronouns are the best fit for me.
Not everybody wants pronouns used at all. Pronouns are important to the individual. So for example, she, her is important to me. in terms of my binary identity, but I can never assume by meeting someone that I can possibly know what their pronouns are. And so the best course of action I find is if they share pronouns, then I now know and I can use them and I know that they're comfortable with those pronouns. If they don't, then I don't assume, or I try my best not to.
What we know is that when you speak to somebody and you address people with the proper pronouns, is that can really validate their existence and their authenticity and their wellness. It's an easy way to say, I see you, and that you're a part of my community.
I think it's very important to use the correct pronouns, as that is how someone feels. That's how they identify. And to me, to not use those pronouns is a form of disrespect or a form of othering, as if they don't matter.
It's a matter of basic respect. It's a matter of recognizing the person in front of you and seeing who they are, right? If you're unwilling to see who they are and say who they are, then I think there's a fundamental dishonesty creeping into that interaction.
If you're able to use the correct pronouns for someone's pets and for someone's kids, why not for the people that you see every day? People misgender dogs and babies and feel terrible about it. So why not, teens and adults too?
I love the story about many First Nations languages having up to 7 pronouns for gender. I want that kind of choice. We're finally uncovering and rediscovering a whole aspect of human diversity, which has been repressed for so long.
It's not that, somebody using the wrong pronouns for me is going to upset me on a personal level. I know who I am. I'm confident in that. But if you know my pronouns and I've told you, it's important to use them because I'm still a human being and you're not respecting my wishes. And pronouns are such a simple thing for somebody to purposefully misgender somebody. It's disrespectful.
Yeah, so we often get questions about just the basics of pronouns. So what are they? Personal pronouns are words to refer to a person without naming that person, and everybody has them. The two that we're usually most familiar with are she, her, hers, and he, him, his. But the belief that those are the only 2 personal pronouns that exist is really cisnormativity. So another common pronoun is they, them. And yes, it definitely can be used to refer to a single individual. And that kind of language has existed for many, many years. We do it often in life without even thinking about it. For example, if you have a package delivered, you might say, your package from the store is here. They dropped it off earlier, when referring to the delivery person. And many non-binary, agender, and other people use they, them pronouns. And we would recommend it as a best practice to use they, them until you know someone's pronouns, including when you're referring to strangers that might look, obviously to be a specific binary gender. And they, them, he, him, and she, her may not resonate with everyone. So there are examples of other pronouns that are sometimes called neo-pronouns, like Z, hears, or AM, airs. And as Melissa said in that video, some people may not use pronouns at all. They prefer you just to use their name. Lots of different options there. And ultimately, I think it's just important to respect everyone's pronouns and refer to them as they identify and how they ask you to refer to them. And person might not necessarily understand why another person chooses different pronouns. But if you're, for example, a man and someone were to refer to you using she, her, hers pronouns and continue to do it despite you having corrected them, it wouldn't feel very good. So, and of course, if one accidentally uses the wrong pronouns for someone, it's best to just simply correct yourself, briefly apologize, and move on. And it's totally okay generally to ask if you're unsure of someone's pronouns. You can ask politely and privately, my pronouns are she, her. May I ask what yours are, and just respecting that they may not want to disclose them necessarily. So just a little intro there, and I will pass it over to Ashley.
Thanks so much for that introduction. And so that was a great video, and thanks for Spectrum for putting that on. I think it's on your YouTube page. I know I've seen it before on your social media page. And so when we're talking about pronouns in the workplace, which is what we're going to talk about today, not only is it's disrespectful to not use someone's pronouns that they use, but it can also be discrimination. It can be discriminatory under the Human Rights Code, and we'll talk about what that looks like in some cases out of the Human Rights Tribunal and what folks can do if they're experiencing that in the workplace. So I'll just give a brief overview of the services we offer at Waterloo Region Community Legal Services. We service low-income Ontarians and folks in the community. We do a lot of work around housing. We represent tenants at the Landlord-Tenant Board, or we give summary advice or information to people if they have questions. So if you're renting, you have questions about something that your landlord is doing or about a lease, or if you're being evicted and you need to know what steps you can take, we can help you with that. We do a lot of work around social assistance, so around Ontario Works and Ontario Disability Support Program. If people have applied or they have questions about applying or they've been denied and they need to appeal that denial, we do assistance with that. We have employment lawyers on staff. I practice employment law. There's another employment lawyer. So if you have any issues around anything to do with your employment, you can call and get free legal advice from us. We have an immigration lawyer. We have an Indigenous Justice Coordinator on staff who's actually on this call today, Lou Roberts. She's great. She provides great cultural services to folks that identify as Indigenous in the community. I coordinate the Sexual Harassment in the Workplace project at the clinic, which is what I'm here to talk to everyone about today. And we do a lot of different types of public legal education. So if you want to check out our YouTube channel, we've got recorded sessions like this one will be recorded and put up on our YouTube page. If people want to learn more about different areas of law, you can check out our YouTube channel. Or if you have an inquiry about something and you want to know if we can do an education session, just reach out. We'd be happy to do that. So the Sexual Harassment in the Workplace project is a project where we're providing free education to different groups, and we're also providing free advice and representation to survivors of workplace sexual harassment. And so for all of our services, we give free legal advice, and then we're able to typically we're able to provide representation to people if you're a low-income Ontarian. But if you have any questions about anything, you're not sure if you qualify, just call and we'd be happy to talk. And if we can't assist you, then we can refer you to someone who can. So we're going to do just a couple true false questions to get people thinking about what do you know about sexual harassment in the workplace. And so we've got a poll we're going to put up. Excuse me. And so the first question is, managers or supervisors are the most likely to cause sexual harassment. So do you think that that's true or false? Give it a couple minutes. Looks like most of the folks have participated. And so these answers are actually based on reported statistics. So the answer to this is actually false based on reported statistics. And what we can talk about maybe and think about ways that maybe the statistics aren't always 100% accurate or align with the reality that people are experiencing in the workplace. So in 2018, there was a Statistics Canada study done. And in that study, 15% of people who experienced sexual harassment in the workplace said they were targeted by supervisors or managers, in comparison to 56% of people who reported experiencing workplace sexual harassment who said they were targeted by clients or customers. And the rest of the percentage were targeted by colleagues or peers. So in that study, or that Statistics Canada report, the lowest reporting was actually people who were targeted by managers or supervisors, even though everyone here thinks that's probably 100% the answer is true. And so if we think about statistics, there's lots of reasons. I don't know if anyone wants to comment on maybe like what's a reason why these statistics may not be accurate, or a reason. If anyone feels comfortable going off mute and sharing why you answered true to this, you're welcome to.
Can you hear me?
Yeah.
Okay, I can wager a reason with statistics because there's less managers, supervisors than like say the general public, which is what was the most. But I think I said true is because my thoughts around the power imbalance around a manager versus an employee. But what you said makes sense with statistic wise. I just think that managers, supervisors would just be more gregarious than others, but maybe not, because it makes sense that the most would be from the general public and like service positions.
Yeah, thanks, Lou. I think that's right. I mean, I think my initial thought thinking about this was thinking about the power imbalance as well, right? We know managers and supervisors are in positions of power and they can abuse that power. And we hear stories about managers and supervisors abusing their power all the time. So, but statistically, you're right. There are more clients, more customers, more coworkers. So that makes sense. Thanks for sharing. Okay, so our next true false question, 2S LGBTQ plus workers are more likely to experience gender-based harassment. Do you think that that's true or false? Okay, looks like most of you participated. 78% of, oh, maybe if I hit end poll, I don't know if you can see the results. 78% of you think that this is true, and 22% of you think that this is false. So this is actually true. There was a 2020 Statistics Canada survey completed. And in that survey, 47% of 2S LGBTQ plus workers had experienced discrimination on the basis of gender identity, or sexual orientation, compared to only 22% of non-2S LGBTQ plus workers. So that's from 2020. And, you know, I think it's good to have these studies and these reports which show things that we anecdotally already know to be true. So it's really great to have surveys that can support these things and research done. I'll just tell you a couple of other research studies that have been done. So there was a UK-based study in 2019. And in that study, it found that 68% of LGBT, so they use the term LGBT in their study, LGBT people referred to being sexually harassed at work. And in that, of that 68%, 2/3 of those people didn't report it to their employer. And 1 in 4 of the LGBT folks that they surveyed who didn't report said they were prevented from raising the issue with their employer for fear of being outed at work. So that was one of the concerns. We know there's lots of reasons why people don't report sexual harassment, lots of barriers to people reporting, and this is a specific barrier that's been identified in this UK study for folks that are 2S LGBTQ members of that community. And the interesting thing in that study was it noted it was talking about unions and the support of unions. And in that study, they found that having being a member of a union, people were more likely to report their experiences of sexual harassment to their employer. They were more likely to report that they found that it was being taken seriously, and they were more likely to say that they felt like it was dealt with satisfactorily by their union and their employer. So that's an interesting thing to note as well. So let's go to our next true false question. Employees in the service industry experience the most sexual harassment. Do you think this one is true or false? Okay, it looks like 100% of you think that this is true. This one is actually false. So this is again based on that 2018 Statistics Canada report. It found that healthcare workers were actually the most likely to report sexual harassment. They were reporting at 22%. And then folks in the service industry were reporting at 17%. So there's not a huge discrepancy. There was folks in the trades that were reporting at 16%, and then education, law, and social services were reporting at 15%. So there's not a huge discrepancy, 22 versus 15%. We know what these statistics really tell us is that it's happening across all industries. I don't know if anyone wants to share, and I forgot to ask this for the last question, but if anyone wants to share their like rationale or their reasoning for why they picked a certain thing, you're welcome to like go off mute and share. I'd be happy to hear. When I was doing this for doing a presentation around sexual harassment in the workplace for a group of nurses, they said, hey, you know, like we consider ourselves part of the service industry. So they didn't think of themselves as their own like separate industry because they consider what they're doing to be part of the service industry. My initial thought in reading this question, I would think that would be true. You know, your people are like on the front line providing service. You're being exposed to customers and clients on a regular basis. Maybe you will be more likely to experience sexual harassment. But if you think about, you know, the intimate type of care that healthcare workers are providing, so under the healthcare umbrella, we've got, you know, nurses, doctors, personal support workers, all kinds of different types of careers that are providing really intimate care, and can be to folks that are sometimes, you know, folks with dementia, for example. I hear a lot from clients who are providing personal support care in homes of people who are senior, have dementia, and providing really intimate care when it comes to like bathing and personal hygiene. So they're just possibly at higher risk of experiencing sexual harassment. Okay, so there are the answers. Sexual harassment is it's a very broad type of, it's a huge type of different types of behaviors that can constitute workplace sexual harassment. I like to think of it as like a big umbrella with a lot of things that fall underneath it. It's always unwanted behavior, and it's generally behavior of a sexual nature, but it doesn't always have to be of a sexual nature, as we'll talk about when we talk about those pronoun cases from the Human Rights Tribunal. What it does is it's behavior that's creating a volatile, hostile work environment. It's behavior that is impacting the dignity of the worker, and it's really about exerting power over someone. It's not really about like attraction or anything like that. So what we know about sexual harassment in Canada is we know that it's happening constantly, that we have reporting that 52% of, so these are gendered statistics, but what we know from Statistics Canada is that 52% of Canadian women have reported experiencing sexual harassment in their working lives. And 28% of Canadian women have experienced non-consensual touching in the workplace in their working lives. And then in terms of that sexual harassment piece, so 52% of Canadian women, 72% of those women say they never reported it. So we know it's happening commonly, it's happening frequently, it's happening to people of all genders, and it's going underreported for a variety of reasons. So the Ontario Human Rights Code has a number of protected grounds which are set out. So you're not allowed to be discriminated against on the basis of a variety of grounds, and particularly in employment. So that's what we're going to focus on today. The code offers protection in other areas, other social areas, but we're going to talk about employment today. And the code also has a number of other protected grounds, things like race, ethnic origin, age, and disability. And so you're not allowed to be discriminated on the basis of any of those code grounds, but today we're going to focus on the ones that are here in this gray circle, which are sex, gender, sexual orientation, gender identity, and gender expression, because those are typically the grounds where we see when we're talking about sexual harassment. And we see sexual harassment manifesting in these three categories. So we often see it being verbal, visual, or physical. And sexual harassment can include and encompass a wide variety of different types of behaviors. And typically what we see in cases, and anecdotally what I hear from clients, is that things usually start off in the verbal category. And then they can, if they go unchecked, they tend to escalate up into the physical sexual harassment category. So I don't want to spend too long talking about the legal definitions, but I'll let you know that there are protections under the Occupational Health and Safety Act and the Ontario Human Rights Code for workplace sexual harassment. And both of those, in particular, the Occupational Health and Safety Act sets out a variety of things that your employer has to do to try to keep you safe in the workplace. And when we're talking about these categories, there's no exhaustive list when it comes to these things. So if you're thinking something that happened to you maybe, but I'm not sure if that counts as sexual harassment, I'd encourage you to get legal advice, because it's a wide variety of behavior that can constitute workplace sexual harassment. So when we're talking about verbal sexual harassment, this is typically things like, quote unquote jokes or inappropriate comments that are being made, questions about, like, intrusive questions about your sex life, questions about your gender identity, and anything that, what the Ontario Human Rights Code says is that it's typically getting at things that are a pattern of behavior or a series of behavior, although a one-time comment or a one-time joke or one-time conduct certainly can constitute workplace sexual harassment. Typically, we're talking about a pattern or a series of behavior that would constitute workplace sexual harassment. And there's different ways. So employers will have policies. So they may have like a zero tolerance policy where they're going to say, like, one-time comment or joke being made certainly can constitute sexual harassment, and maybe it's going to get you in trouble in the workplace. Maybe you're going to be disciplined, or you're going to have to undergo training or be educated on what you're doing or saying, but that may not rise to the level of workplace sexual harassment that's required under the Ontario Human Rights Code. So there's different things that constitute maybe a violation of an employer policy versus the Human Rights Code. The Human Rights Code is really getting at a pattern or a series of behavior. And like I said, if one time thing is happening, it can constitute workplace sexual harassment, but it needs to be like a serious one-time thing. So when we're talking about visual sexual harassment, this can include a bunch of different things, but it can include, sending someone inappropriate text messages or emails, showing someone pornography in the workplace, sending along inappropriate things that have visual content in it that you're sending to a coworker. And physical sexual harassment can include a bunch of different types of things. Like on the far end of the spectrum, of course, is sexual assault, but it can include any sort of non-consensual touching, even non-consensual touching that maybe isn't overtly sexual. So someone like grabbing your arm or grabbing your leg or anything like that certainly can constitute workplace sexual harassment as well. And so I want to spend a bit of time now talking about these recent human rights decisions. So they're not from this year. From like hot off the press, but I think they're really important to talk about today on International Pronouns Day, because they both deal with the use of pronouns in the workplace. So they're both from 2021. There's one from the Ontario Human Rights Tribunal, and there's one from the British Columbia Human Rights Tribunal. And they're both great cases. And it's really encouraging as a human rights lawyer to see these cases coming out and seeing how they're being treated by the adjudicator and the care that's going into the decision that's being written by the adjudicator, because these are cases that we can use going forward, and they give us insight into what kind of evidence we need to make a successful case going forward on these issues. So I'm going to tell you a bit of detail about these cases because I think they're interesting and they're good to know. The first one that we're going to talk about is EN versus Gallagher's Bar and Lounge. This is the March of 2021 decision from the Human Rights Tribunal. And you'll see that this is an anonymized decision. So where they're using the initials EN. And I like to tell people that is an option. If you're going to the Human Rights Tribunal, you can request to have a decision anonymized. If sometimes people are concerned about having like a public decision with your name displayed, and that doesn't have to be the case. You can request to have your name anonymized, and that was done in this case. So this case actually, so EN is the main applicant, but this case actually involved 3 workers that all worked at a restaurant. EN identified as genderqueer, and 2 of the other applicants identified as non-binary trans people, and all 3 of them used they, them pronouns. And now what's interesting about this case is that the employer didn't defend it. So all we have in this case is the evidence that was submitted by EN and the other two applicants. And it was uncontested evidence because the employer didn't participate in this hearing. And so what we know is that EN asked their manager to use they, them pronouns, but the manager refused, and he persisted and continued to misgender EN and the other two applicants throughout their employment. And a really key factor to this decision was that the manager was overheard talking about EN and the other two applicants to some customers at the bar using a transphobic slur. And so this information got back to EN. EN told the tribunal, gave evidence that this made them feel very unsafe in the workplace, essentially being outed by their manager to customers in the workplace. And it's obviously very hurtful and very, very scary for them. So EN approached their manager and raised these concerns. The manager denied making these comments, even though they came from a credible source, and the Human Rights Tribunal ultimately found that this transphobic slur was said. The manager denied it, and the manager made comments essentially saying that they felt like they had to quote unquote walk on eggshells around these applicants when they were trying to use proper pronouns. So EN and the other two applicants, they tried to approach these issues with their manager. Managers denied it, made a number of more offensive comments. And so EN and the other two applicants, they stopped going back to work, and they said essentially they found that their employment was constructively dismissed. So what that means is if you are in a situation where you feel like you can't go back to work because of harassment or discrimination that you've experienced, you can essentially quit your job, and then you essentially quit because you can't go back. And it's seen as in law, you'd argue that it's effectively a termination of your employment because your employer is not making it a safe, supportive environment for you to continue going to. And so the Human Rights Tribunal here in Ontario found that this was discrimination, and this was discrimination on the basis of gender identity, gender expression, and sex. This is some interesting quotes I have up here from the decision. The adjudicator said, genderqueer and non-binary trans people are a historically disadvantaged group protected from discrimination. So noting that they're the historic disadvantage of this group, the adjudicator said the transphobic slur, quote unquote, was made in a public setting to strangers, customers in the workplace, effectively outing the applicants in a derogatory and non-consensual way and causing them to fear for their safety. And so when it comes to the misgendering piece in this decision, the adjudicator said that misgendering or the use of incorrect pronouns is adverse treatment. So what that means is you are being treated differently in the workplace because of your gender identity or your gender expression. But unfortunately, in this case, the adjudicator said there wasn't enough details, there wasn't enough information for them to really make significant findings when it came to the misgendering piece. So that's why I want to talk about the next case, the BC case, because that was a fully adjudicated hearing, which means that both sides participated, there were cross-examinations, and parties were fully involved, and there were a number of really key findings that the British Columbia Human Rights Tribunal was able to make that weren't made specifically here at this Human Rights Tribunal decision in Ontario. But the adjudicator was, essentially said that when the manager or the employer was approached about these comments that were being made, the slur that was being made, they didn't handle it. They were dismissive, and then they ultimately insinuated that the applicants were being, too sensitive, and went on to talk about having to walk on eggshells. And this is not an appropriate way for an employer to respond when someone's coming to them to talk about harassment and discrimination that they're experiencing in the workplace. So in this case, all three of the applicants were awarded $10,000 in general damages, and they were also awarded lost wages. So lost wages is a type of remedy you can get from the Human Rights Tribunal if you can show that, but for the discrimination or the harassment of the employer, you would have continued to work, and you would show how much you would have earned in that period of time. So they were awarded that remedy as well. So you know, when we think about damage awards, $10,000, it's not a ton of money, but it's significant to have this decision from the Human Rights Tribunal to say, you know, that misgendering someone in the workplace, using transphobic slurs, that is discrimination. And we all know that, but it's good to have cases that state that specifically. And, you know, $10,000, it's not nothing, right? So it's a bit of money in the pocket of these people who had to experience this discrimination. So the next case we'll talk about, and if anyone has any questions about these cases, I said it, but I'll just remind folks, if anyone has any questions, please feel free. I'm happy to chat about these cases or anything you may have questions about. The next case, which also came out in 2021, September 2021, is from the British Columbia Human Rights Tribunal. It's Nelson versus Goodberry Restaurant Group. And this case involved just one applicant, Jesse Nelson, and non-anonymized. So Jesse, the applicant, made a decision not to ask to have their case anonymized. Jesse is a non-binary, gender fluid, transgendered person who uses the pronouns they, them. And Jesse was working as a server at this restaurant. And when Jesse started at the restaurant, Jesse had a conversation with their manager. Jesse had recently come out as being trans and had a specific conversation with their manager about how they needed to be properly gendered in the workplace, how it was really important to them, and that it was a daily struggle for them having their pronouns properly recognized. So there's a quote from Jesse, which I'm going to read because I think it's a good quote. Jesse said, "It's not easy, it's not simple. Anytime I'm in a relationship with any other person, whether that's getting a coffee or going to the grocery store, I'm almost always misgendered. I'm either referred to as Miss or Ma'am, or I've had people assume that Jesse's a shorthand for Jessica. It's a daily conversation that I'm in." Jesse had this conversation with their manager before starting at the job and was really happy that the manager was actually being very supportive. The manager said he would speak to the staff and everyone at the restaurant, have a conversation to ensure that Jesse was going to be properly gendered while working there and feel safe. That manager actually did that and on occasion would correct coworkers who were misgendering Jesse. Now there was an older male who worked as a bar manager who predominantly this case is about, and that older male refused to use they, them pronouns, consistently misgendered Jesse, used very gendered nicknames like sweetheart, sweetie, and honey. And when confronted, Jesse had a few times where they tried to confront this coworker. The first time in Jesse's testimony and evidence, they said it was sort of a very gentle approach of saying, I understand if you can't use they, them, but you can at least just call me by my name. And then two more times, Jesse had to approach this coworker. And on the third time, it was kind of a heated conversation where this older male coworker made comments like, "You're not allowed to tell me what to call you. You can't police my language. This goes against what my grandfather fought for in the war," and comments of that nature. So Jesse's evidence was essentially that there were a lot of coworkers who tried their best. Sometimes they made mistakes and they would correct themselves whenever they made those mistakes. And that's really not what this human rights application was about. This human rights application was really about the treatment of that one who consistently misgendered Jesse and used those gender nicknames and was doing it on purpose to hurt Jesse. And then also this human rights application was about the employer's response when all of that went down, because essentially what happened is, because of that last interaction between Jesse and the older coworker that got quite heated, Jesse's employment was terminated. And when Jesse pushed for a reason as to why their employment had been terminated, they were told that they'd come on too strong, too aggressive, and they had been too quote unquote militant. So this is a really good decision. The adjudicator was very thorough, and there's a lot of good quotes. So I'll just read this one quote I like that I have up on the slide. It says, like a name, pronouns are a fundamental part of a person's identity. They're a primary way that people identify each other. Using correct pronouns communicates that we see and respect a person for who they are. And then the next bullet point here is another really good takeaway from this case. It says trans employees are entitled to recognition of and respect for their gender identity and expression. This begins with using their names and pronouns correctly. This is not an accommodation. It's a basic obligation that every person holds towards people in their employment. So it's really important that and that the tribunal identified that this is not an accommodation. This is a basic need that has to be met in employment. When we're talking about accommodation, we often see that language around things like disability in the workplace. So, if someone has a physical disability or mental health disability, they can request certain accommodations by their employer. And I think it's really important that the Human Rights Tribunal here is signifying that pronoun use is not an accommodation. It's something that needs to be done, it needs to be met, and in not doing so purposefully, intentionally, you are discriminating against someone in the workplace. And so I want to tell you ultimately what happened with this case, but there were some other quotes I wanted to read. So ultimately, Jessie was awarded $30,000 in damages from the British Columbia Human Rights Tribunal. And then human rights tribunals also have the ability for what's called public interest remedies. So you can request other things from human rights tribunals. So this tribunal also ordered that the employer had to implement a pronoun policy, and they had to implement mandatory training for all their staff and managers when it came to diversity, equity, and inclusion. And of that $30,000, $10,000 of it was awarded specifically to that employee who continued to misgender Jessie and use those very gendered nicknames. So it's a good case. I'm happy to talk more about it if anyone has any questions. Briefly, I'll tell you about the employer's obligations in the workplace. So when it comes to sexual harassment, which it encompasses discrimination on the basis of those categories, those protected grounds, we talked about sex, gender, sexual orientation, gender identity, and gender expression. All that falls under sexual harassment and discrimination. And so your employer has to have a policy when they were talking about sexual harassment in setting out how they're going to respond and deal with complaints. They're supposed to provide training to their staff. They have to conduct an investigation if a complaint is being made, and they're supposed to provide you with the results of those investigations. And ultimately, they're supposed to ensure the privacy of everyone that's involved. That one can be tricky to do, especially if you're working at a small company. If you're a small employer, sometimes things get out, or but your employer is supposed to do what they can to ensure everyone's privacy. And if your employer is not doing these things, there's steps that you can take. So I don't want to talk in too much in detail about the steps that you can take, but I'd encourage you, like if you've experienced sexual harassment, discrimination in the workplace, and you've reported it to your employer and they're not taking it seriously, or they don't have a policy, they're not doing what they're supposed to be doing, there are steps you can take. So get legal advice and find out what those options are. And when it comes to best step practices and best steps that you can take as an employee. In that first human rights case, we saw the tribunal wasn't really able to make a finding when it comes to misgendering. And that's because they didn't have the particulars, they didn't have the details they needed about the misgendering, how often it happened, when it was done, what was said. So if you, I hope that you're not experiencing this in the workplace. If you are experiencing any sort of discrimination or harassment in the workplace, I can't stress enough how important it is for you to document those things. And you need to document it in as much detail as you possibly can. So, if you are being misgendered in the workplace by a coworker who is doing it constantly, consistently, you want to write down like when it is, what's being said, who's around, and how did it make you feel? And you can do that in a journal or a diary. You can do that by sending yourself an email, whatever way you're comfortable with. Just make sure that you document it all, so that if it comes time, hopefully, it can be resolved. But if it comes time to go to a human rights tribunal or court, or you're having a grievance arbitration or anything like that, you have all of those details documented, because memories fade and we can't always remember exactly what's said and when it's said and how it made us feel. So documenting all those things is really important. Employers, when it comes to employers' best practices around pronoun use, the law doesn't specifically say what doesn't set out what an employer has to do. So these are just best practices, some ideas that employers can implement if they want to be treating their employees with respect, doing the best things that they can in the workplace. So having a policy around pronoun use, or having something set out in writing in a policy is a good idea. Having regular and frequent training for staff. So that's not just when a new staff member is coming in and onboarding, but you want to have that continuing development, continual training, because it was actually said in the British Columbia case, but we are unlearning, right? We're in the process of unlearning years and years and years of this idea that there's only she and her, he and him pronouns, and we're in the process of unlearning. So training is essential for staff. We need to be trained. We need to let folks know that that's not the case, and that they need to respect employees and colleagues and peers, and be respectful. And then there's the using gender neutral language best practices. Just have a policy where you're using gender neutral language in all of your policies and your procedures, in the way that you are greeting clients, customers. And this was actually something that Jesse mentioned. So I didn't talk about this one fact of the case, but there was a staff meeting where everyone was involved, and the manager at one point said, if anyone has any tips or anything they want to suggest. And Jesse and another coworker made a suggestion about how great it would be as if when customers are coming into the restaurant, if they could use gender neutral language to greet customers. So they were making suggestions for ways that the employer could be more respectful. And that's a suggestion that can be used by all employers, right? All employers can think about ways that they can use gender neutral language in the way that they're providing services to clients and customers. So not just for the way that they're treating their employees, but how they're providing services to customers as well. And having a complaint resolution process that's easy, for not only an easy process to navigate, but an easy process for folks to access. So employees should know what that process is. Who do they go to? Where's the policy? They shouldn't have to ask for it and dig around. It should be accessible. It should be something that people can find easily, and they know if something's happening, I make a complaint to this HR person or this manager, and that should be clear and easy to access. And this one, including pronouns on email signatures and business cards, maybe that's not a best practice if folks don't feel comfortable sharing their pronouns. But if folks feel comfortable sharing their pronouns, then certainly, stating it in as many places as you can. And Scott mentioned at the beginning, using they, them pronouns at the beginning before you know somebody or before someone identifies what their pronouns are is definitely a best practice. So when it comes to reporting sexual harassment or any sort of harassment or discrimination, if you feel comfortable to talk to the person, you can do that. Obviously, there's lots of situations where people wouldn't feel comfortable doing that, approaching the person. And so it's certainly not a legal requirement that you do that. But if you do feel comfortable doing that, you can. There's certainly different ways it can go. If it comes to pronoun use, it may be as easy as someone saying like, oh, I'm sorry, I didn't realize that I was doing that wrong, and correcting their action. But then you may be in a situation where it could be someone who's doing it on purpose, or someone who is not an easy person to approach, or it's not safe for you to approach that person. So you definitely don't have to. Finding out what your company policy says about reporting harassment, this one you do have to do. So for an employer to be on the hook for any sort of liability at the Human Rights Tribunal or in court, they have to be aware of the harassment, and so you have to let them know. You have to let your employer know. And I encourage people to do that both verbally and in writing with a written complaint. And like I said before about keeping a record of anything that's happening to you, but also keeping a record of whatever formal reporting steps you're taking. So really documenting everything that's happening to you in terms of the harassment, but also documenting what's happening in terms of who you're reporting it to, what their response is, what's being done. You can insist internally that your employer have an investigation. You can find out what the results of that investigation are and find out if there was any consequence or if anything was done. And if, things aren't improving in your workplace and you want to know like what your steps are beyond working with your employer, I'd encourage you to get legal advice. If you're unionized, the union's a really great place to start as well. And at the clinic, we give free legal advice on these things. So I'd encourage you to contact us, or, there's the community legal clinics in almost all communities in Ontario that provide similar free legal advice services. So reach out and find out what your options are. Okay, so I'd like to leave a few minutes for questions. If anyone has any questions, I'm happy to chat. If you don't feel comfortable asking now, my email address is there. You can certainly email me and we can set up a time to talk. Also, we have I'd ask you or encourage you to follow us on social media. So we've got Facebook, Instagram, and Twitter, and that's at SHIW, that's the Sexual Harassment in the Workplace, and WR Waterloo region. So you can follow along. We post different types of events like this, and we post infographics and articles and information so you can learn more about sexual harassment and what your rights are in the workplace. And I'd like to have more discussion and have time for questions, but I'll leave this slide up as well. So these are some great community resources if you need some support after this presentation, and Spectrum as well as a great resource if you want to talk to Scott and find out what services are available. So does anyone have any questions? Comments?